My name is Shakti Vadgama. I'm an attorney at MNK Law, where we fight to protect businesses throughout California. Before we begin, please don't forget to like, comment, and subscribe to our channel for more resource videos like this one. Today we're going to discuss the laws regarding what must be included with an employee's paycheck. Under Labor Code Section 226, employees must be given a detachable part of their paycheck or a separate writing showing required information every time they are paid their wages, whether by check, in cash, or otherwise. This information includes the following 8 items. Number 1, gross wages earned. Number 2, total hours worked. However, this is not required for salary-exempt employees. Number 3, all deductions made. Number 4, the net wages earned. Number 5, the dates of the period for which the employee is paid. Number 6, the name of the employee and the last 4 digits of his or her social security number or employee identification number. Number 7, the name and address of the legal entity that is the employer. And number 8, all applicable hours in effect during the pay period and the corresponding number of hours worked at each hourly rate by the employee. Now, if the employee is paid on a piece rate basis, it must include the number of piece rate units earned and any applicable piece rate. An employee suffering an injury as a result of a knowing and intentional failure by an employer to include each of these items on the employee's paycheck is entitled to recover the greater of all actual damages, or $50 for the initial pay period in which a violation occurs and $100 per employee for each violation in the subsequent pay period, not to exceed an aggregate penalty of $4,000. An employee is also entitled to recover costs and reasonable attorney fees. An employee is deemed to suffer injury if the employer fails to provide a wage statement and/or fails to provide accurate and complete information as required, and the employee cannot promptly and easily determine such information, meaning a reasonable person would be able to ascertain the information without reference to other documents or information. Moreover, a knowing and intentional failure does not include an isolated and unintentional payroll error due to a clerical or inadvertent mistake. In reviewing for compliance with this section, the fact finder may consider as a relevant factor whether the employer, prior to an alleged violation, has adopted and is in compliance with a set of policies, procedures, and practices that fully comply with this section. Lastly, it's important to note that a copy of an employee's wage statements and records of deductions must be kept on file by the employer for at least 3 years at the place of employment or at a central location within the state of California. A copy includes a duplicate of the itemized statement provided to an employee or a computer-generated record that accurately shows all the information required under the Labor Code. Employers must provide copies of wage statements to employees upon written or oral request within 21 days of the request. That wraps up our video for today. For more information of an employee's wage statement, visit our website at mnklawyers.com or contact us at info@mnklawyers.com. Thank you. See you in the next one.